Hello everyone, welcome to the MUTES program on Criminal Justice Administration. I hope you are going through the other modules of mine. I am Dr. Upma Gautan, Assistant Professor, University School of Law and Legal Studies, Guru Gobind Singh, Indraprastha University, Dwarka. So today I would be giving you a lecture on compounding of offences. The objectives of this module would be to acquaint you about the various procedures provided in CRPC through which a criminal case is disposed of without completing the trial. Secondly, to explain you about the substantive and procedural aspects of the compounding of offences. Thirdly, to expound before you about the role of judiciary and also the emerging trends as to the quashing of proceedings regarding non-compoundable offences by the High Court exercising inherent powers under section 482 CRPC and also by the Supreme Court under article 142, 136 of the Indian Constitution. And last but not the least, to explain you the social objectives to be fulfilled by such compounding provisions. So let us start. As you all must be knowing that once the criminal proceedings are initiated either by a police officer or by a magistrate, it is not necessary that they are concluded, as there are certain provisions in the code which provides the disposal of proceedings before the completion of trials. For example, compounding under section 382, withdrawal of proceedings by the public prosecutor under section 321 CRPC, plea bargaining which is provided under chapter 21A, the quashing of criminal proceeding under section 482 CRPC, stopping the proceedings under section 258 CRPC, death or non-appearance of the complainant in someone's case under section 256 CRPC, and also if the accused takes the plea of guilt under sections 229, 241, 246 subsection 2, 253 in various types of trials. So this is just to elaborate what I have said earlier. Now, when you define the crime, there are various definitions that are given by the authors from in various point of time, but none of the definition of crime is exhaustive. So now why I am referring to the definition of crime here? Because if you remember the definition of given by Kenny, he talks about, here I quote, about the crime as the wrongs whose sanction is punitive and is in no way remissible by any private person, but is remissible by the crown alone if remissible at all. Now, the Kenny talks about the remissibility as a special feature of the crime, which can, in the case of crime, it can be remissible. That means pardoned by the crown alone. That means a private person cannot remit the wrongdoings if it is a criminal proceeding. But the Kenny's definition finds its criticism in the provisions given under section 320. Why? Because according to section 320, the compounding can be done, or in other words, that the remission can be done by the private person. So now let us see how this compounding is done. First, we'll understand why the compounding provision is present in this code. See, though essentially in serious offences, no compromise between the wrongdoer and the victim can absolve the liability of the accused. But there are many offences which are either of a private nature or are comparatively less serious as are made compoundable in the Code of Criminal Procedure. So, the compounding can be either done without the permission of the court or with the permission of the court under the provisions of the code, and in this case it is section 320 CRPC. Now, the basis of classification of compoundable and non-compoundable offences is the degree of wrong done to the state by the commission of the offence. So, if more wrong is done, that is the degree of wrong is more, the offence is made non-compoundable, and if it is comparatively less, then the offence can be made as compoundable or is made compoundable under section 320. Now, coming to the rationale of compounding provisions in CRPC, see, these compounding proceedings terminate the criminal proceedings in respect of certain categories of offences which do not affect the interest, security of the state or are not having grave impact. So only these kind of offences are made as compoundable in section 320 CRPC. The second rationale which is behind providing the provisions of compounding can be and is that at times it becomes very cumbersome and burdening, not even for the courts but also for the victim to continue the proceedings. So in those cases, in the interest of justice, it becomes necessary to dispose of the proceedings without completion. So when the interests of justice are so served by such compounding, condoning is allowed, and such condoning not only puts a victim in a better situation but also lowers down the burden of the court in proceedings which have become infructuous due to amicable settlement between the parties. Now, coming to the nature and scope of compounding under section 320. Section 320 of the Code dealing with the compounding of offence contains provisions, firstly, regarding the offences and nature of offences that can be compounded. Secondly, who can compound such offence with or without consent of the court. Thirdly, the stage of the criminal proceeding at which the composition is sought to be made. So at what stage the composition can be made. So that we will study in the later part. What is compounding? Now, before coming to the procedure of the compounding and modalities attached to the compounding, I would like to tell you that what do you understand by compounding? See, it is a composition, it is a settlement or an arrangement between the injured party and the person under section against whom a complaint is lodged. That means it is an arrangement or settlement between injured party and the accused. Now, it is not necessary that the composition should be in writing, as it can be oral, as well as especially in cases of offences which are compoundable without the permission of the court, definitely it can be oral. Now, if the both parties agree that there has been compromise, then the court has to dispose of the case in terms of that compromise. But if parties differ, then the court has to call up both of them to lead evidence and then record a finding on such evidence whether allegations regarding the compromise are true or not. You should keep it in mind that if the offence is compounded, as is also given in section 320, all the criminal proceeding against the accused are terminated and the offender stands acquitted. The effect of compounding is acquittal. It is not discharge. It is acquittal. And compounding doesn't mean, but the compounding doesn't mean that the offence has not been committed, but it only means that it was committed, but the victim is willing either to forgive or to condone the part of the offence, the whole of the offence, in lieu of some solatium, in lieu of some compensation that is to be received from the accused. Now, the one factor I have discussed earlier also, but we'll discuss it in detail, that what is the basis of making an offence compoundable? See, the first basis of making an offence compoundable is that the wrong that is to be considered to be done against the state. Now, compounding can be either done without the permission of the court or with the permission of the court. Without the permission of the court, the list is given in the first list and the second list is done with the permission of the court. Now, the offences which are not mentioned in either of the lists, the offences are non-compoundable. So, the list of non-compoundable offences is not given anywhere. Only it is implied that whatever offence is not covered in either of the lists, they are non-compoundable. Now, but the offences in special acts or local laws are to be taken as non-compoundable unless the legislature decides the offences mentioned therein to be compoundable. Now, it is the degree of the wrong done, as I have told you earlier also, it is the degree of the wrong done to the state that decides and that forms the basis of the offence being made as compoundable or non-compoundable. Now, petty wrongs done to the citizens which do not seriously affect the interest of the community or the state are compoundable by the injured party without any reference to the state. That is, such offences can be compounded even without the permission of the court. Now, the class of offences where sanction of court is necessary to compound consist of cases where the injury to the state is recognized. They are much grave in nature in comparison to the offences mentioned in the list 1. But the state considers it expedient in given cases on the basis of the discretion exercised by the judicial authority to permit the aggrieved party to compound the offence. Now, as I have told you that the offences which do not form part of the either list, they are non-compoundable. So now, in order to determine whether a case is compoundable, deciding factor is the offence for the commission of which the accused was charged, or else with which the accused charged him. But that is not the sole factor. A magistrate should always use his discretion and wisdom to decide upon what offence is made out of the complaint and the police report, because the exaggeration of facts is something which is always there. Now, as far as the stages of compounding is concerned, which forms the third part of it, the section 320 is silent about the stage of the criminal proceedings at which the compounding is to be done. But the compounding of offence in the said section is only permissible when the case is pending before the trial court, before the appellate court or the revisional court. So, now as far as the next question comes on the screen is that compounding pending investigation. Now, what about, see, compounding is to be done by the court. It is to be done before the court, either with the permission or without the permission. But now the question here is that can a compounding be done if the investigation is pending? Now, section 320 of the code doesn't provide that whether the offence can be compounded pending investigation, because as I have said earlier also, it is silent about the stage of the compounding. But varied practice are followed in different states in this respect. We should not forget that there is nothing to bar a compounding to be done at the stage of investigation in the section. So, section per se doesn't prohibit that. So, what is provided in the code is that it should be done by the court and during when the proceeding is pending. So, now let us understand what will happen in this case. A written complaint, or does happen in this case, a written composition can be filed before the police by the person who can compound the offence, or else even a joint complaint can be filed, a joint application can be filed. The police will verify the genuineness and voluntariness of the claimed composition, that yes, the composition has been reached on, and in order to do so, the officer can even record the statements under section 161 CRPC. Now, if such police officer is satisfied that the offence falls within section 321. So, now this offence regarding which the application is so filed during investigation, either it will fall under 321 or will fall under 322. That means either in the first list that the offence is compoundable without the permission of the court or with the permission of the court. So, if the offence falls within the first list, that is section 321, then in that case, the police will file a negative report under section 173 subsection 2, in which the charge sheet is filed. So, in that, a negative report will be filed to the magistrate. Now, upon receiving such report, the magistrate can take appropriate action accordingly after notice to the de facto complainant. But if the offence regarding which the application is being made, either single-handedly or jointly, in that case, if the offence falls within the second category, that means the offence can be compounded with the permission of the court, then in that case, the police officer will seek the proper orders, the appropriate orders from the court, that what is to be done regarding this, and then why? Because the compounding cannot be done without the permission of the court. So, this is the legal position as far as the compounding at the pending investigation. Now, as far as the agreement for compounding is concerned, court persists on bilateral agreement, but the accused need not be rigidly called to be a party to the compromise petition by affixing his signature, as it is not a prerequisite for giving an effect to compounding. Meaning thereby that the initiative of compounding should come from the complainant. That is something that is to be seen by the court of law. Though ideally should be a bilateral agreement, but if it is coming from the complainant, then that is fine enough. So therefore, a unilateral petition submitted by the complainant is operative towards the composition of an offence, and there is nothing wrong about it. Now, section 321 does not require the permission of the court. Therefore, as soon as the parties have arrived at the composition agreement, the magistrate has nothing more to do except to record a judgment of acquittal. Now, in this case, the court will not call the parties, but if they differ, yes, as I have said earlier also, then in that case, the court will go into the genuineness of the composition. And while doing so, the magistrate will use its discretion. But coming to the offences which are mentioned in the second list, thereby meaning the offences which are compoundable with the permission of the court, it is the duty of the court to examine the nature of the offence and the evidence, and thereafter should satisfy itself as to whether permission for granting composition is to be given or not. Now, it is desirable in offences of a serious nature that such permission should be granted after due scrutiny and due time should be taken. That means it should not be done mechanically, rather it should be done with the application of judicial mind, and then accordingly the permission should be given. So, once a composition is effected, it cannot be withdrawn. You have to remember this, it cannot be withdrawn. Why? Because it becomes completely, and also it becomes completely immaterial that whether the terms of compromise have been carried out or not. Why? Because we have to draw a logic regarding this. See, I have discussed this, that the court becomes infructuous regarding that. Once the matter is being decided, now that is out of the purview of the court. Now, in that case, the court is having no powers regarding that matter. Okay, so once the compounding agreement is not being satisfied, the conditions are not being satisfied, it is not that now anything can be done. That we have to be very clear. So, because, and also there is one more reason added to it, that the compounding is having an effect of acquittal, and therefore it deprives the magistrate of its jurisdiction to try the case. Therefore, any subsequent withdrawal from it by any of the party can neither affect the acquittal nor revive the jurisdiction of the magistrate to continue with the proceedings. So that is to be categorically kept in mind, that once the compounding is done, it is irreversible. It cannot be retrieved back. To come to the next part of the lecture, see, I have told you that the offences can be either compoundable, either non-compoundable. Compoundable, then with the permission of the court, without the permission of the court. But let us say if the compounding is to be done regarding non-compoundable offence. So now the question is whether the compounding can be done regarding non-compoundable offences or not. Okay. So now that we have to understand what are the judicial trends, because again the section is silent about that. Now, with the due emphasis attached that an offence which law declares as non-compoundable, they cannot be compounded by the courts using their inherent powers. This I have pointed out earlier also. Now, the High Court, even in the exercise of its inherent power, cannot permit compounding of non-compoundable offence, as pointed out earlier. There are other provisions in the CRPC which disposes of the criminal proceedings before the trial is completed, amongst which the most important section is section 482, by using which the proceedings can be quashed even before the trial starts or the trial is completed. And also Article 142 and Article 136 of the Indian Constitution, by which the Supreme Court of India can quash the proceedings, can quash the criminal proceedings. Now, Understanding the latest judicial trends regarding the compounding in case of non-compoundable. But I'll not say in the true sense it is compounding in non-compoundable offences, but it is the ending of the proceedings in non-compoundable offences. What are the judicial trends regarding that? Now, in Maheshchan versus State of Rajasthan, the Supreme Court allowed the compounding of offence under section 307, that is attempt to murder, Indian Penal Code, which is a non-compoundable offence. And you will agree to that it is a serious offence also. But in this case, the Supreme Court said that no, it can be compounded. Again, in Ramlal versus State of Jammu Kashmir, the Supreme Court, while overruling the decision in Maheshchan, held that in light of express prohibition in section 320, an offence which is declared as non-compoundable by the law cannot be compounded at all, even with the permission of the court or even by the use of inherent powers. So, it was overruled, but again, in B.S. Joshi versus State of Haryana, the Supreme Court held that the offences under section 498A, that is cruelty by the husband and his relatives, and section 406, Indian Penal Code, the High Court can quash the proceedings under section 482. Now, this was the change of view, that in section 482 and accompanied with section 406, the court can compound the offence under section 482 despite the fact that the offence is non-compoundable. In this case, the Supreme Court defended such quashing of proceeding even though the offence was non-compoundable on account of securing end of justice, taking a cognizance of special fact and circumstances. So, if there are special facts and circumstances, the court can even compound the non-compoundable and can allow compounding under section 482. Now, further, B.S. Joshi was approved and reaffirmed by Apex Court in Gulabdas versus State of MP and also in Nikhil Merchant versus CBI. I'd like to give a reference of one more case that would be Bankat versus State of Maharashtra, in which it was held that non-compoundable offences could not be compounded and was later followed by the Karnataka High Court. Again, now this is a change of view. In Nazimun Nisa versus State of Karnataka, in which the proceedings were not allowed to be quashed under section 482 CRPC when the offence is under section 498A. So, now this is a changed view as was mentioned, as was affirmed by B.S. Joshi, Nikhil Merchant and also Gulabdas. So, this was again the U-turn by the court. Again, in Gyan Singh versus State of Punjab, the B.S. Joshi was followed, in which it was held and affirmed that the offences arising out of matrimony, relating to dowry, etc., or family disputes, or where the wrong is basically of a private nature or personal in nature, and the parties have received their solatium and they have resolved their disputes, the High Court may quash under section 482 of the code. And this power is different from the power available to the criminal courts and to compound offence, which is there under section 320. So, Gyan Singh said that section 320 will not have an overriding effect on section 482, and 482 is something under which the courts can even quash the proceedings regarding non-compoundable offences. So, coming to that, the powers of the Supreme Court regarding quashing of the proceedings, again, even the powers of the Supreme Court to quash the criminal proceedings are not curtailed by section 320. So, we can conclude that the High Court in the exercise of its inherent power under section 482 can quash criminal proceedings, FIR or a complaint, and section 320 does not limit or affect the power. Now, in Narendra Singh and others versus State of Punjab and another, the Supreme Court bench comprising of Justice K.S. Radhakrishnan and Justice A.K. Sikri issued fresh guidelines for quashing the proceedings in non-compoundable offences, which are, and I quote here, number 1, that the powers of the High Court under Section 482 CRPC to quash the proceedings on the basis of settlement between the parties is different from the power of the courts for compounding the offences under Section 320 of the Code. So you have to differentiate between both of the sections, Section 482 and Section 320, and both are different. The second is the guiding factor for the courts to reach on the decision of quashing of proceeding on the basis of settlement between the parties is to secure, number one, ends of justice, number two, to prevent abuse of the process of court. So these are the two guiding factors that, keeping in mind, the court can allow the quashing of the proceedings even the offence is a non-compoundable offence. Now thirdly, the power under Section 482 should not be exercised regarding the heinous crimes like murder, rape, dacoity, etc. because the brunt which the society faces due to these offences excludes the proceeding in such offences to be terminated on account of compounding. So, just as a matter of policy, the compounding should not be allowed. Coming to the next guiding factor is that the proceedings can be quashed in those criminal cases which are predominantly of civil nature, particularly the cases of matrimonial disputes, family disputes, or disputes involving commercial transaction. Now, in these cases, if the parties have resolved their differences, the proceedings can be quashed even though the offences are non-compoundable. Now, offences under Section 307 IPC is a heinous crime and is considered to be an offence not only against an individual but also against the society. Therefore, the High Court, primarily considering the nature of injuries inflicted, the manner in which injuries were inflicted, and also the part of the body where the injury was inflicted. Now, why the court has given this as a guiding factor? Simply because it will tell the intention of the person, the manner in which the injuries are inflicted. So, they should be kept in mind by the High Court, and then the High Court should decide whether the proceeding should be quashed or not on the basis of settlement between the parties. Now, again, for exercising under powers under Section 482 by the High Court, the timings of settlement plays a vital role, meaning thereby that if the settlement is arrived immediately after the commission of the offence, pending investigation, then the High Court may adopt a liberal approach and can quash a proceeding on the ground of amicable settlement between the parties. That is, more advanced the stage of criminal proceeding is, the lesser the court will allow the quashing of the proceedings. Now, these are the quashing of the proceedings. What are the guiding factors? Again, I'll just quickly tell you that to secure ends of justice, to prevent the abuse of the process of the court, definitely it should be done rarely. It cannot be exercised just as a matter of practice. Criminal cases primarily of the nature of matrimonial, family disputes and commercial transactions, they should be allowed. The compounding should be allowed in these cases, and also the chances of conviction. Now, the courts have also laid down certain conditions and circumstances where the compounding should not be allowed. Now, what are these? First of all, in special acts, compounding should be avoided, and specifically in case of SC and ST Prevention of Atrocities Act, because the chances are more that the person is being influenced. Now, the second is in heinous crimes like murder, rape, dacoity. Now, if the offence is committed by a public servant during the discharge of his public duty, and also if that compounding is against the public policy. After discussing this entire topic, you must be realizing one thing, that the compounding is one procedure given in the procedure and provision given in the CRPC, which terminates the proceeding before the completion of the trial, thereby serving two major purposes. One, it lessens the burden of the victim as well as it lessens the burden of the court. Definitely subject to certain conditions, but one thing now that is coming up again and again is that the scope of the compounding should be broadened. More and more offences should be included within the purview of the compoundable offences, so as to further decrease the burden of the courts and making criminal justice system more friendly. Okay, so now there are series of debates going on, and specifically in case of section 498A, you must all be knowing now and then the courts are giving observations regarding the misuse of section 498A. So the debate is going on that let us make section 498A as a compoundable offense, and if you will see the bare act of the Criminal Procedure Code, you will come to know that in the state amendments, the Andhra Pradesh government has already made 498A as a compoundable offense. So if the Andhra Pradesh government has initiated making a 498A offense a compoundable offense, then why not make it a compoundable offense in general, applicable to all the states? So yes, even Law Commission in its 237th report recommended that section 498A should be made compoundable with the permission of the court, and the same has also been suggested by section 154 Law Commission. And the same has also been suggested by Malimat Committee and also in 154th report of the Law Commission. Substantiating this, Preeti Gupta versus State of Jharkhand, Ram Gopal versus State of MP. The courts have observed that section 498A should be made as compoundable, provided yet another justification for making it compoundable. Why? Because see, 498A, again, it's a matrimonial dispute, more of a nature of matrimonial dispute, and it is always advisable, keeping in mind of the nature of the offense, that if the parties have agreed to the have reached to an agreeable settlement, then in that case let it be compounded. Now regarding section 324, now the debate is going on regarding section 324 IPC also, which is including the offense of hurt by dangerous weapons, and means it was suggested by 237th report of the Law Commission that it should be also made compoundable, but with the permission of the court. Again, in 154th report also the Law Commission suggested the same. The Apex Court also expressed the same opinion in Sanjay Kumar Divakar versus State of Bihar, stating that 324 should be included within the second list, that is the offense which are compoundable with the permission of the court. So Supreme Court and the courts are the other courts are also substantiating the recommendations given by the various by the Law Commission in the various reports. So regarding 498A and 334, yes, the time has come to make it as a compoundable offense. After the entire discussion, I'll conclude by saying that it is being again and again recommended by the Law Commission in its various reports and also by the Supreme Court that the more and more offences should be included within the purview of section 320, which would be not only beneficial to the criminal justice administration, but will also be beneficial to the victim and also to the society. So on this note, I'd like to conclude and end up my lecture, wishing you all the good luck and all the best for your exams. And if there is any query, please do let me know. I'll be more than happy to answer them. You can upload them on the website and you'll be receiving my reply. Thank you.